Well, when we think about privacy or privacy regulation, we usually talk about the Fair Information Practice Principles, the FIPS. And big data challenges several of the FIPS. It challenges the principle of data minimization, which has always been a privacy law principle, some would say the organizing principle for privacy law, and is antithetical to big data, which is all about data maximization. The more data you have, the more refined the learnings and the lessons that can be drawn from it. It also challenges the principle of purpose limitation, because the principle basically says that data are collected for a predetermined purpose, and yet with big data analysis we try to draw unanticipated, sometimes surprising correlations or conclusions which simply can't be predefined. And it also challenges the principle of consent or individual participation, because when individuals consent or agree to their data being collected or used, they do it for a specific purpose, whereas some of the great value of big data is repurposing the data and using them for to draw lessons which couldn't be anticipated in advance. So these fair information principles, these privacy principles, are challenged by the big data framework. Yeah, okay, so but you touch on two very fundamental concepts of privacy law: the definition of personal data, or PII, and the concept of individual participation or consent. With respect to PII, in the past we had a concept of anonymization or de-identification as a silver bullet solution to any privacy problem. The idea was that data can be anonymized, stripped of their identifying features like individuals' names or social security numbers, and thereafter used or analyzed for different purposes. Computer scientists have repeatedly shown that even de-identified data can be linked to specific individuals, effectively re-identified, sometimes with not much effort in terms of computing power or effort put into it. So once that has been shown, some argued that any data should be subject to the privacy framework, because any data can ostensibly be at some point, and given some degree of effort, be linked to specific individuals. Personally, I think de-identification is still a very important concept, because it reduces privacy risk. So it might not be 100% secure solution, and some organizations with very strong incentives might be able to re-identify data that have been de-identified, but I think for most intents and purposes, de-identified data can be considered as safe to use. And I think helpful concept that was introduced by the FTC in its recent final report this March was overlaying technological de-identification with legal obligations. So a commitment on the part of data controllers not to try to re-identify data, which can then be enforced against them by, for example, the FTC, and also contractual obligations that are imposed downstream by those controllers on their processors or business affiliates. So I think if you have a reasonable de-identification plus self-commitments not to re-identify and downstream contractual obligations, you should still see the data as exempted from most of the privacy principles. With respect to your question on consent, I think consent is a very problematic aspect in the privacy sphere because consent, I think, is seldom informed in this context. The data ecosystem has just become so complex that even professionals would have problems trying to understand it and to provide specifically informed consent to their data being used. And it's also seldom freely given because usually if you want a service, you will just agree to any language boilerplate that's thrown at you by an organization and just click through in order to get to the service. So it's not informed, it's not really voluntary, and therefore I don't think it's very meaningful from a legal point of view. I would say that the emphasis should be not on individual decisions or consent, but rather on policymakers trying to delineate which uses of data are fair and should be practiced, and which uses of data are harmful and not beneficial enough in order to justify privacy infringement. Yeah, so the idea in the paper that I was discussing, which I wrote together with my colleague Jules Polonetsky, who's director of the Future of Privacy Forum, tries to analyze the tension between a big data ecosystem and privacy law. And we say that some of the fair information principles may have to be modified or relaxed in order to fit the big data reality, namely the principles of data minimization, purpose limitation, and individual participation or consent. On the other hand, we argue that other principles should be emphasized, namely access, accuracy, and security. And with respect to access, this is a principle that's been in privacy legislation for quite some time now, but has seldom been practiced by individuals, because if individuals ask to access their data, usually they'd have to go through a lengthy process, sometimes costly, and at the end of the day they would get, if they get anything, they would get data in hard copy, which is not usable or useful in any way to them. We think that access should be useful and that businesses should provide individuals with their data in usable, machine-readable format in order for them to be able to harvest their own data for their own use. And when we talk about the featureization of data, we think that if individuals have access to their personal data in such a way, and if there is sufficient demand for it, then services and applications will develop on the user side to provide individuals with these services based on the data that they access from other service providers. So for example, if I could access the data that Google maintains about me through their various services, or that Microsoft maintains through their various services, and I could have access to it in machine-readable form. Some application developers may provide me with services trying to analyze, for example, how often I should exercise, what I should eat, what I should buy, where I may want to travel, things like that. And I think even targeted advertising might then come into demand from the user side as opposed to being imposed by service providers, and it would make it more popular in a way that way. So and that's what we mean when we say the featureization of big data. Yeah, so when we say individuals should get access to their data, we don't mean access to trade secrets or copyright or intellectual property of companies, but rather to their personal information. I don't think that personal information should be viewed as an asset of business. Personally, I don't think personal data should be viewed as an asset of individuals also. I think the property metaphor doesn't fit personal data, which should be viewed as an individual right, a fundamental right, and not a piece of property. But even if you accept the property framework, I think personal information certainly shouldn't be viewed as the property of businesses, even if those businesses, through their intellectual property and trade secrets, which should be protected, were able to successfully solicit individuals to provide those data. Yeah, so the right to be forgotten is one of the novel concepts that the European Commission submitted in its latest legislative proposal. Several proposals, actually. There's a proposal for a new regulation and also for a new European directive. And in some ways it echoes a right that was already in the European Data Protection Directive from 1995, and that's the requirement that businesses and organizations not retain data for longer than is necessary for the purpose for which the data were collected in the first place. And I think that's a sound principle, and it has applied and will continue to apply. However, if you expand that principle to something more than that, which is, first of all, an individual right to require deletion of data, and second, an obligation on certain companies, basically online intermediaries, to go after data that's already been transferred to third parties in order to delete those data based on an individual's request. The right becomes, first of all, unworkable, not practical. I think, second of all, it imposes an overly burdensome obligation on online intermediaries to police the internet and to arbitrate in decisions and conflicts that may implicate conflicting individual rights. For example, your right to free speech against my right to privacy. And I don't think that online platforms like Facebook, for example, or Google or Microsoft are well placed to arbitrate those arguments. I think that obligation shouldn't be imposed on them. And finally, I think the right to be forgotten, as currently phrased, might overly infringe on the freedom of speech and challenge the balance that we have in the internet environment between speech and other fundamental rights. So I don't think it's a helpful addition to the existing framework of internet regulation. Yeah, so there are various differences between the conception of privacy in the US and the EU. And they go really to the source of what privacy rights mean and where they came from in the different jurisdictions. So in the US, we usually go back to the Warren and Brandeis article from 1890, the right to privacy, and their formulation of the new, at that time, legal right to privacy was the right to be let alone. And that underlies US privacy law. It's a right to be left alone, especially vis-a-vis the government. The right to protect yourself against government intrusion into the private sphere. So it can be into your home, or it can be into decisions, for example, about reproduction. So, of course, the Roe versus Wade decision, which has a privacy rationale built into it. On the other hand, in Europe, privacy is seen as emanating from dignitary rights, and the motto there would be not right to be let alone, leave me alone, but rather respect me, give me respect, respect my dignity, my informational self-determination, as the German Constitutional Court called it in its 1993 decision in the census case. So that's one big difference. Somewhat ironically, from an historical perspective, in the US, individuals are more concerned about privacy infringements by the government and seem to be more at ease with businesses using their personal information. Whereas in Europe, despite a very dark history of government misuse of data, both in the Nazi period and then in communist East Europe, individuals seem more concerned about businesses and agree to let governments actually protect them from businesses' use of information. So that's another difference. Another difference, I'd say, is that in the US, as we discussed a couple of minutes ago, privacy is tied to proprietary interests, or is seen as related to property, and is therefore viewed as a consumer issue. So in the US, we talk about consumer privacy, and when the White House recently submitted its white paper about, it's called the Blueprint now, on privacy law, it talked about the Consumer Privacy Bill of Rights. In Europe, privacy is not seen as a property interest or a consumer issue. It's seen as a fundamental human right. And that accounts for some of the difference in European regulators' willingness to see individuals forego those rights for sometimes monetary or other gain. It's not viewed as a quid pro quo transaction.